immigration attorney in Spokane Valley, Washington, and Coeur d'Alene, Idaho. Immigration law is a federal law, so we immigration attorneys practice in all 50 states. As I've mentioned in my previous presentation, on September 8, 2022, the Biden administration released the final rule on public charge as a ground of inadmissibility. This rule will become effective on December 23, 2022. And will apply to applications submitted on or after that date. As of today, the public charge rule that was implemented by the Trump administration in 2019 is cancelled, and we are currently and until December 23, 2022 are going to utilize the public charge rule consistent with 1999 field guidance. So the first question is, who is subject to this rule? In general, applicants for green cards, those who apply for their green cards abroad through an immigrant visa process, or those who apply for their green cards inside the United States through the process called adjustment of status. Who is exempt from the public charge ground of inadmissibility? First, applicants seeking refugee or asylee status, persons seeking T non-immigrant status, so victims of human trafficking, persons seeking U non-immigrant status, victims of criminal activity. Also, applicants seeking temporary protective status, TPS, applicants seeking registry, certain applicants seeking recognition as American Indians born in Canada, and finally self-petitioners under the Violence Against Women Act, which is known VAWA. So which public benefits does the government consider when determining whether an applicant is inadmissible under the public charge ground? First, it's supplemental security income, which is known as SSI. Second, cash assistance under the Temporary Assistance for Needy Families, which we know as a program called TANF. State and local cash assistance programs that provide benefits for income maintenance, general assistance programs. And the last one is institutionalization for long-term care at government expense, such as in nursing home or mental health institution. And lastly, which public benefits does the government not consider when determining whether an applicant is inadmissible under the public charge ground? First, it's Medicaid and other health insurance and health services, including emergency medical services. Second, the children's health insurance programs. Next, nutrition programs, including food stamps, housing benefits, childcare services, energy assistance, emergency disaster relief, foster care and adoption assistance, educational assistance and job training programs, and finally, community-based programs, services or assistance such as soup kitchen, crisis counsel and intervention, and short-term shelter. Besides, the government doesn't consider cash payments that have been earned, such as Social Security benefits, government pensions, veteran benefits, etc., etc. So this pretty much covers our today's topic, and during my next presentation I will address such issues as how obtaining benefits under the COVID-19 assistance is going to affect the public charge determination, and how obtaining public assistance by family members like children who are United States citizens is going to affect their family members, for example parents, who are going to apply for their green cards in the future. So stay tuned.